All right, I'm live now. Okay. And it might be because the damn music up the top. YouTube might be cutting it because of like copyright or something. I don't know.
Oh yeah, I didn't think about that.
Yeah, yeah. All right, guys. Hopefully you can hear me this time. We had some technical difficulties. I'd like to try to do these things on live feed so that anybody who wants to listen to the lecture, that's great. But uh, I can't issue a certificate unless you attend in person and you also do the live fire portion. According to Colorado law, it's 8 hours in person. None of it can be done virtual. I disagree with it, but that's the law, and that's how we have to do it for the time being. And we've already gone through a lot of the law. For example, we've gone through deadly physical force and physical force definitions. We went over storage laws for Colorado, et cetera, et cetera. So um, now we're going to go into the extreme risk protective orders. So we're going to get it started on that. Okay. So here in Colorado, remember we're talking about titles and articles and parts, right? Here in Colorado, can you hear me? Let me know if you can hear me. CRS Title 13, Article 14.5 covers the ERPO. We're going to go cover some more definitions as it pertains to ERPOs, or extreme risk protective orders, red flag laws, as we call them. A community member, quote unquote, okay, means a licensed healthcare professional or mental health professional who, through direct professional relationship, provided care to the respondent or the respondent's child within 6 months before requesting the protective order, or an educator who, through direct professional relationship, interacted with the respondent or the respondent's child within 6 months before requesting the protective order. So what does that mean for you? Well, if you ever have a child, remember it's within 6 months, and if they have a professional relationship with you or the child, and they think that you're a danger to yourself or others, they can petition the court to for a protective order. Okay, now that's a community member. Okay, now we're talking about educators. Educators means a teacher employed to instruct students, or a school administrator, or a school district, private school, charter, or school institute, or an individual charter school, or a faculty member of an institution of higher education. Um, so that's pretty cut and dry, but then it keeps going with faculty member. It means a president, dean, professor, administrator, instructor, or research worker in an institution of higher education. Okay? Now we're going to talk about family members, and this is where it just adds to the list of people who can petition the court for an ERPO. And the law can be misused, but statistically speaking, any of these people that we talk about, other than law enforcement, they have a harder time to prove, at least for the time being. They have a harder time getting the petition to be enacted here in the state of Colorado. Um, so family or household member means, with respect to respondent, a person related by blood, marriage, or adoption to the respondent. That would be potentially you, right? A person who has a child in common with the respondent, regardless of whether such person has ever been married to the respondent or has lived together with the respondent at any time. So if you have a child with anybody at any time, that could be a petitioner. A person who regularly resides or regularly resided with the respondent within at least 6 months. A domestic partner of the respondent. A person who has a biological or legal parent-child relationship with the respondent, including step-parents, stepchildren, and grandparents and grandchildren. A person who is acting or has acted to the respondent as the respondent's legal guardian. a person that falls in the intimate relationship as defined: spouses, former spouses, past or present married couples, a person who are both the parents of the same child, regardless of whether the person has been married or had lived together at any time. So that's a lot of people that can petition the court. So be careful who you marry. Be careful of who you talk to and how you talk to them, because if they want to abuse the law, they can attempt to abuse the law, which is unfortunate. So to sum this all up, any of the persons can request an extreme risk protection order against you, which is a healthcare professional, a mental health care professional, a teacher or school administrator, a president, dean, professor, administrator, instructor, or research worker in the college or university, a law enforcement officer, a spouse, former spouse, relative, or any other parent of a legal, or the other parent of any legal children, past or present lovers, right? So that's a lot of people, okay? So just be careful. Like I said earlier, statistically speaking, anybody outside the law enforcement community, if they petition the court, they have a hard time to get the court to act on the ERPO. Now, on the other hand, if law enforcement officers do it, they have an easier time getting the ERPO granted, okay? Now, let's say they do get the ERPO granted, and it's a temporary order. It's a year long, okay? And if that happens, the court shall issue a temporary extreme risk protection order, and they have to notify the respondent the day or the day after the order was made, okay? The court shall issue a hearing within 14 days, business days that is, and the respondent is to surrender all their firearms to either law enforcement or an FFL, and we'll get into that in a minute. The law enforcement officer that serves the respondent is supposed to take those firearms into their possession. Let's say I was the law enforcement officer and I came up to you in your house and say, hey, this is your extreme risk protection order. I need your firearms, for example. And you inform me that you plan on giving them to an FFL. I'm still supposed to take possession of those until you coordinate the transfer with the FFL, okay? That's as a law enforcement officer supposed to do that, right? Let's see. The law enforcement officer, is supposed to issue a receipt, right? And that receipt needs to have the make, model, and serial number of the firearm, and firearms, rather, because in a year's time frame, when the extreme risk protective order expires, you can recover your firearms. Okay, that temporary order, red flag order, let's call it. It's good for a year, and you need to make sure that receipt is valid, meaning make sure every serial number is to the T correct. Because if they fat finger it, let's say they put a 9 instead of a 6, and then you go and say, well, this is the serial number I had. They're like, well, that's not the serial number we have, and they'll keep the firearm and dispose of it, if that makes sense. So make sure the receipt issued by the law enforcement officer, if that was to ever come, is absolutely 100% correct. Okay. When it expires, any firearms that were surrendered to law enforcement personnel must be returned after a background check, investigation, and confirmation the order is no longer valid, okay? Unclaimed firearms in law enforcement possession may be disposed of if unclaimed after 1 year of order expiration. So, if there's a temporary order issued, that's going to be a year long. And then after that year long is going to expire, you have a year to reclaim your firearms. So we've covered a lot of state laws. Again, it's going to take some research on your part to understand them in full. But we covered what deadly physical force is, what physical force is, when you can use deadly physical force or physical force. We understand what a dwelling is, what a business establishment is. We understand that we cannot use deadly physical force to defend property. We can only use that to defend life, okay, and serious bodily injury. Um, but at the end of the day, all these laws are confusing. So it's best to avoid confrontation, secure your firearm, keep your firearm from unauthorized personnel, attempt to de-escalate the situation, and if required, you can defend yourself and be prepared to call 911 directly after, okay? So again, further study might be required on your part. So now we're going to the federal law. So we covered the state law, now we're going to the federal law. It's going to be the federal law is going to be pretty quick, right? So there's a couple things we're going to talk about here. And then we're going to listen to some video of lawyers talking about the federal law. It's better for you to hear from lawyers who actually study this stuff than from some schmuck that got his verified training certificate, okay? All right. So 18 U.S. Code, Chapter 44 deals with general firearm federal laws, okay? You can read any of these sections to further your knowledge later, okay? The National Firearm Act of 1934, this basically gave the feds the ability to exercise the taxing power of the NFA. And so that basically they levied a $200 tax for short-barreled rifles, short-barreled shotguns, and suppressors, right? Now, currently that's up in the litigation, whether that's a valid thing or not. In fact, I think they just, with the big beautiful bill, they made that tax not $200 anymore. It's now $0. So you can still get these items, but you still have to register them with the ATF. But you're not paying a tax anymore. Okay, and we'll see what happens with that here in the state.
Yeah. Seems like they were still saying you have to have a tax stamp, which
Yeah, you have to have a tax stamp.
seems like you're not going to be able to get after they.
Nope, you get you still get the tax stamp. You're just not paying a tax.
Okay.
Yeah.
Got it. Okay.
Yeah, so you still have to get the tax stamp for suppressors, short-barrel rifle, short-barrel shotguns,
Okay.
but you're not paying the $200 tax. It's no longer.
Okay.
Okay.
Got it.
Which is it's good. It's not good in the sense of like, okay, short-barrel rifle, short-barrel shotguns, and suppressors shouldn't be any more scrutinized than just regular rifles, let's say. But it's good for Colorado because the way Colorado law is worded, if it were that way, then I don't think Coloradans would be able to legally grab those things anyway, state-wise.
Yeah.
All right. The Gun Control Act of 1968. Okay. Among other things, it created minimum ages for purchases, so 18 years, and then the requirement that all firearms be affixed with a serial number, and the expansion of categories of prohibited persons, okay? Now, that's 68. Don't get confused here. That's the GCA of 68, okay? And this is FOIPA of 86, okay? Okay. 68, 86. So FOIPA basically prevented the federal government from maintaining a centralized database of firearms dealers' records, but all FFLs have to maintain their records, I think, for life. Yeah. So they can always reach back to those FFLs to get them. Even though it's not centralized, they can always reach back to get them.
Access to.
Yes. All right. FOIPA also is called the Peaceable Journey Law because now the federal law is basically saying, let's say we're in Colorado. Let's say we're going to, through Illinois to go to another state. Let's say we're going through Illinois to go to West Virginia, okay? Because I know the West Virginia laws are better, okay? So let's say we're going to go from Colorado to West Virginia. We have to pass through Illinois. Illinois is not very gun friendly, okay? But you can still pass through that state with your firearm as long as you meet the following criteria. Legally speaking, okay? It has to be unloaded and in a locked container and away from your reach, okay? So you cannot stay in the state where it's prohibited. So let's say, for our example, if we're going through Illinois, we can't stay in the state, right? We can't. I don't even think you can stop there. Now, I don't know particularly if you stop for gas, if that means stopping, but definitely if you stop to stay there, that's stopping. Okay, so let's see. It must be unloaded and contained in a lockbox and out of the driver's reach. And you must pass through the state without stopping. Like, again, I don't know if getting gas is one of those things, because some of these states are so large. Let's say if you're going to go through New York, you're probably going to have to stop for gas at some point. Okay, so just be careful with that. And that brings me to, if law enforcement officers stop you, they have to have probable cause to search your vehicle without your consent. Okay, so the best thing to do is to comply with them, and then if they want to search your vehicle, don't give them consent. But you can say something like, I'm not going to stop your investigation, but I do not give you consent to search my vehicle. And that may give your lawyers some power to get any evidence that they obtain from your vehicle as inadmissible in the court. Does that make sense? Okay.
Is the Firearms Owners Protection Act of 1986, or what is some kind?
So we're going to listen to the Washington Gun Law. I highly suggest you subscribe to their channel. This is a guy out of Washington. He's a lawyer. Very good stuff. That's kind of where I learned a lot of my stuff from, my education when it comes to these various different laws. So we're going to listen to him. And then if you guys can't listen on the screen, I'm sorry. I got this microphone here, and it's not plugged into the computer.
Referred to as FOIPA. Now, this was passed during the Reagan administration. It was meant to address some of the constitutional concerns that had come out of the Gun Control Act of 1968. And despite the fact that there had been several pieces of significant litigation on that piece of legislation, there was still general concern that portions of that statute could in fact be unconstitutional. This statute, which actually granted gun rights back to individuals, passed under President Reagan, made it easier to transport long guns across state lines. It also allowed for the shipping of ammunition through regular postal system or through UPS or things such as that. It ended the federal registration for ammunition purchases on all ammunition except for armor-piercing ammunition. And perhaps one of the most significant components of this legislation was the safe passage provision, which allows individuals to carry firearms through states and as they're doing interstate travel, which may otherwise have very restrictive firearms, but allows individuals to travel through the state so long as the firearm is properly secured in their automobile, consistent with the safe passage provisions. Now, this legislation did not come.
Okay. So you heard it straight from a lawyer what the FOIPA is. Okay. We'll continue. Okay. Now the Bipartisan Safer Communities Act, that did a lot of things, but it also added prohibited persons. It prohibited a person convicted of a violent misdemeanor against a current or recent former dating partner from possessing a firearm for 5 years. So, if you're convicted of a violent misdemeanor against a past partner, let's say, then you're prohibited from having a firearm for 5 years. Federal transportation laws. We already kind of covered this with the FOIPA. This is just the law, the 18 USC 926 alpha. We already covered it with talking about the act. All right, let's talk about air travel. This one is near and dear to my heart. I've known some people who thought they were in the right, but they were wrong. and they got hemmed up or got fined. Okay, so here's the gist of it: no ammunition in your firearm, no ammunition in your magazines. The ammunition needs to be packed in either its original packaging, just the way you buy it from the store, or in a a a a, a box designed to hold ammunition. So if you're like a reloader, the reloading boxes will work too. You can carry up to in your checked baggage, your checked luggage, you can carry up to 11 pounds. I think it's actually 11.11 pounds or something like that. 11 pounds. And in your lockbox that we already talked about, right? It needs to be your unloaded firearm in there, your unloaded magazines in there, not in the firearm, and your ammunition can be in the same box, but in that original packaging, locked away. And your box cannot be able to be pried open, okay? So typically what's going to happen is that you're going to go to the counter, the reception, and you're going to say, hey, I have a firearm to declare. The lady or the guy behind the counter is going to say, okay, cool. Fill out this piece of paper and put it on or in your locked box. Sometimes I've had them tell me both ways, right? You're going to put it on or in your locked box, whatever their directions are. And here at Denver International, they're actually going to grab your luggage and escort you to where it's going to get scanned. From there, after it's scanned, then they're going to take you to a conveyor belt, and they're going to put it on a conveyor belt, and then it goes on the plane from there. Okay, but you have to make sure. I have to make sure this is completely clear for all the viewers. No ammunition in your gun. No ammunition in your magazines. Magazines out of your gun. The empty gun, the empty magazines, and your ammunition in its original packaging can go in the lockbox that cannot be pried open, and that's the way you travel with a firearm. All right. Because if not, if you don't do that, you can get fined. And let's say you mess up and you have ammunition in your magazine, they'll take not only your magazine but all the ammunition with it. Okay, so make sure you do that. Now, if you want to read this for yourself, you can go to the what's it called, the TSA. You can go to the TSA website. You can read it for yourself, but it's defined in 49 CFR 1540.5. Okay, so 49 is the code of federal regulations. All right, we're going to talk about general safety rules, firearms retention, storage of your firearm, carry of your firearm, and then when we get out to the range, we'll talk about proper clearing and unloading. Proper loading and clearing the firearm, excuse me. All right, the NRA likes to say there's two ways that typically accidents happen. I'd say there's three ways, okay? Ignorance, carelessness, and arrogance. Ignorance, obviously, not knowing what to do, and you have an accidental discharge, let's say. Carelessness, obviously knowing what to do, but you're just careless about it. I'm sure you've seen videos of call them thugs doing their thing, and they're super careless with a firearm. And arrogance, knowing what to do, but thinking that it's not going to happen to you. Okay. There was one time in my career where I don't want to guess it was more of a carelessness thing, not necessarily arrogance. We're using ammunition rounds. We're in a dark room. We're done with our training. I went to go clear the firearm. Again, ammunition rounds, not real, but still embarrassing to say the least. I did my clearing procedure. Again, in dark room, and I didn't use white light. I pointed into the wall and pulled the trigger, which is the last part of the clearing procedure that we'll cover later. And then the paintball round went right into the wall. Super embarrassing because I was supposed to be the subject matter expert of firearms. So having the arrogance saying that it's never going to happen to you is not something that I would suggest. Okay. Obviously, ignorance. That's why you're here. You're not going to be ignorant of the caring for a firearm, for example, and arrogance. Obviously, don't be so arrogant, as we're going to see here in a minute. There was a law enforcement officer who was really arrogant while giving a classroom instruction to some kids, and he ends up shooting himself. Okay, so we're gonna watch that in a minute. As a matter of fact, let's watch that now. Let me go ahead and skip to it. Yep, here he is.
I have a gun on my side right here. Just this week, at the beginning of the week, a young boy, not even 16 years old, was killed because he was playing with a gun. And see, this is an unloaded gun. Right here, Mr. No, give me weapon. Give me weapon. This is a Glock 40. 50 Cent, Too Short, all of them talk about Glock 40. Okay, I'm the only one in this room professional enough that I know of to carry this Glock 40. I'm the only.
All right, so yeah, exactly, right. So let's point out some arrogance here. What did he say right before the firearm went off?
I'm the only one qualified to handle this.
So he had an elevated sense of himself, okay, which obviously was not true, okay. The other thing that he was arrogant about was the firearm itself. There's no such thing as a Glock 40. Okay, you have Glock 17s, Glock 18s, excuse me, Glock 17s, Glock 19s, Glock 23s, so on and so forth. But there's no such thing as Glock 40. What he's trying to allude to there is a 40 caliber firearm. Okay, so there's some arrogance there. It may be ignorance, because the way he cleared it is he locked the slide to the rear, and he told his buddy, "Hey, am I clear?" Well, his buddy said yes. So did his buddy actually look in the chamber or even the magazine well, right? And neither did he. So there's some ignorance there. So there's just a couple of things there that we can take from that one video and go, okay, let's not let that happen. Okay, and we'll cover proper clearing procedures, like I said, on the range. Okay. We'll cover it here too briefly with words, but then we'll do some practical exercise on the range. NRA safety rules, they like to say always in big bold letters. Always, always, always. So let's talk about these real quick. The first one, always keep the gun pointed in a safe direction. Is that even possible?
Sometimes, I mean.
Sometimes is not always. Yeah. Always is not sometimes. Yeah. Is it possible to always keep the gun pointed in a safe direction?
I would say in every situation that I've been in, yes.
Okay. All right. So where do you plan on carrying when you get your concealed carry?
Oh, I guess like right here.
Okay.
Which I guess is not necessarily pointed in.
See what I'm saying?
Yeah.
So your firearm, it is impossible to keep your gun always pointed in a safe direction. Now, the premise of that statement is good. Know where your firearm is pointing. Okay? Know what's going on there. But when you go to appendix carry, let's say, it's definitely not pointed in a safe direction, right? Which probably don't want to do a 320 right now in appendix carry. You know the controversy on that? Yeah. So, okay. All right.
Because I have a 365 in there, and I'm like, maybe I shouldn't be using safe for anything, but I guess there's never been a controversy on the 365. So, all right. Now let's go to the next one. And so the first one, we can't always keep it in point in safe direction, but we definitely want to know which way it's pointing. If that makes sense. Yeah.
All right. And notice it's pointing, not aiming. Okay, which way the gun pointing? Because like if I do this,
Yeah.
it's pointing at you, but I'm not necessarily aiming, right?
Mm-hmm.
All right. Now, always keep your finger off the trigger until ready to shoot. All right, there's two clauses in here. Keep your finger off the trigger and then until ready to shoot. So, in your own words, what is until ready to shoot?
I mean, generally what I try to do is until I'm, aimed at the target.
Okay.
Then I'm trying to shoot.
So, I'm going to throw something at you. Here. You said the word target. So, this is a self-defense course. So, what is the thing that you would be pointing at?
Whatever is, causing imminent danger.
Imminency, right? So when we're on the range, when you're on the range ever, if it's steel, if it's paper, if it's whatever it is, always think in your head, this is an imminent threat, okay? Because if you pull your firearm and you point it at somebody, it should be an imminent threat. And the only way you're going to train that is by training your brain to put your finger on the trigger when there's an imminent threat. Does that make sense? So even though it's a piece of paper or steel is not coming at you, we still need to think that it's imminent threat, okay? All right. And then the next one is always keep your gun unloaded until ready to use. This is one that I love to throw at customers because I get several different answers, right? I could have 18 people in the room and each one of them would have a different answer. So again, two parts here. Keep the gun unloaded until ready to use. So what is until ready to use to you?
So I guess at the range, it would be like when it's pointed in a safe direction, like downrange, and then also whenever I have, everything set up downrange.
Okay.
For me to be ready to shoot.
Okay.
And then also whenever everybody's got the proper protection on and everything.
Okay. Yep. I mean, that's good. That's a good answer. What about when you're not on the range?
I guess it would be. I mean, if you're carrying, you have to be ready to use at any point. So it'd just be in the holster, I guess.
Okay. Would it be unloaded?
Not in the holster. No.
Okay. So until ready to use, in your words, would be.
When not at the range, it would probably be when you're ready to holster it to carry, I guess.
I get you. Yeah. Okay. I like the answer, right? So this is what I try to get people to think about is what is until ready to use. In my home, until ready to use is the purpose of the firearm, right? First of all, I have to take that in consideration. So I have pistols that are strategically placed in my home in lock boxes, loaded because they're ready to use. Now my hunting rifles are unloaded and in a safe because they're not ready to use. I'm not hunting in my home, for example. When I go to conceal carry, I have it loaded and in full operational mode because it's ready to use. Make sense? Now, there's a certain amount of comfortability that you have to have when conceal carrying, especially if you're going to conceal carry appendix or on your body or something like that. You have to be comfortable loading that firearm. And then some people may want to keep one out of the chamber. And that is completely fine. It's completely okay to do that. But you have to train that way. And that's the big thing, is being able to train that way and be able to be proficient that way. Those are the big things, okay? So understanding what your firearm is for, the purposes, if it's safe to carry that way, and how comfortable you are. That's until ready to use, to me anyway. That's my own words. Okay. There's other safety rules we can go over, but those are the big three. And the most two important are keeping your finger off the trigger and also understanding where your firearm is pointing. Those are the two big ones that I would say. If none of the other ones are do you remember any of the other ones? The two are the finger and the pointing of the firearm. Because if you point a firearm in the safe direction and your finger is on the trigger and you happen to have an accidental discharge or negligent discharge, however you want to call it,
it's pointing in a safe direction, it's not likely going to create a catastrophic accident. The opposite is true also. If you have it not pointed in a safe direction, let's say if you're going to reholster and your finger is out of the trigger, you're not likely going to have an accident, right? Unless it's the P320. No, I'm just kidding. Kind of, but not really. But anyway, not likely to have an accident. But if you violate both of those rules, let's say if you're appendix carrying or just whatever, you're holstering and you have your finger in the trigger, now you violated both those rules, you're likely going to have a catastrophic accident. Okay? All right, retention of your firearm. If you're concealed carrying, typically speaking, level 1 retention is going to be sufficient. So level 1 being just friction on the firearm itself. It could be like a little snap, for example, with Kydex holsters. Level 2 is you have to defeat something in order to pull it. So you have the defeat device, let's say. It could be a lever, a button, or something of that nature. And then also some friction, okay? And level 3 is there's something you have to go around, and then you have to defeat the device, and then there's the friction, right? The friction part. You'll see that a lot on like police officers. We had them in the military. We took that thing off because the button seemed to be sufficient enough. And then when I carry concealed, when I'm out and about, I just have a level 1, right? So. If you are doing some kind of security work or something like that, you definitely need a level 2 or higher. But typically speaking, if you're still carrying, then a level 1 is good.
Care of your firearm.
I'm not going to make you watch this video. Again, I've gotten better at videos, so I got to redo this one. Typically speaking, you don't have to take apart your firearm and clean it very much. I've got today. I do have a 320 today, an M17 320 today, and I have probably have 1,500 rounds through it. I haven't cleaned it. Yeah, but when you do go to clean it, obviously you want to make sure it's clear. And again, we'll cover the clearing procedures in a little while. And then once it's clear, you take it apart, and you want to wipe it down real good on the insides and outsides. Get the carbon out of there. You have to really pay attention where the chamber is. There's called a feed ramp. Right there, if the carbon gets built up right there, cartridges have a tendency to catch up on the carbon, and then you'll have a type 1 malfunction. So make sure that's clean. Otherwise, anything that's metal on metal, you want to have a little bit of lube on, but not a whole lot, right? Because if you put a whole lot of lube on there and you go to shoot, it's just going to come out of the weapon, and your hands are going to get all greasy and stuff like that. So that's typically what it is, right? The main point there is make sure the firearm is clear. There's no ammunition around when you clean the firearm, and then metal on metal contact. Wherever metal on metal rubs together, you want to have a little bit of lubrication. We've already watched that.
Clearing and loading the firearm.
This is up for debate on how to clear a firearm. I know that another firearms trainer here in the Springs said they don't like to point the firearm in a safe direction, pull the trigger. They think it's stupid, but and that's their prerogative. But here's my argument to that: is that USPSA, the competition, IDPA, and Special Operations Forces use this clearing procedure that I'm going to give you, and it works. So ultimately, there's some steps involved, right? We want to attempt to put on safe, right? Some firearms don't have an external safety, like a Glock, for example, a Canic. Some of your 320s don't have an external safety. But you want to think in your mind, attempt to put on safe because maybe you're at a range and your buddy's like, hey, go grab my firearm or something like that, right? Yeah. Who knows, right? Attempt to put on safe, understanding what safety is. And in some firearms, you can't put on safe because, let's say, the hammer's forward already. Like in 1911, you can't put it on safe, for example. But attempt to put on safe. You want to remove the source of feed. So on a pistol, the source of feed is the magazine. Remove that source of feed, which is what the police officer we watched, what he didn't do. He didn't remove the source of feed. He went out of order here. So attempt to put on safe, remove the source of feed, or remove the magazine, however you want to call it. And then you want to open the action. Now, I imagine you're going to be strong enough and have the dexterity to lock the action to the rear. So pushing up on the locking lever, pulling that slide back, and allowing the lock is way better than holding it and then doing the next steps, right? So if you can lock the action to the rear, even better. So lock the action to the rear. Now we're going to do a 3-point safety check, and that's the chamber, the slide face, and the magazine well. So why are we looking in all those 3 areas?
I mean, check the chamber because obviously if there was one in the chamber before you took the magazine out, you know, you need to be able to see if that's in there. Slide face.
The slide face, that's where the back of the cartridge sits when it's chambered.
I guess if your gun has some kind of malfunction and doesn't eject correctly, I guess it could be stuck there maybe. And maybe same with the magazine well.
Yeah. So, well, you're on the right track, right? So it is a deliberate movement. Instead of going, oh yeah, it's clear. It's a deliberate movement to go, you check in the chamber, the slide face, and the magazine well to make sure that there's no debris in there. There's no rounds, obviously. And you're also looking for broken pieces and parts, right? The other thing is if that police officer, if he did the 3-point safety check, he would have noticed, because he did lock it to the rear, he would have noticed that he didn't drop his source of feed. And he could have rectified the problem right then and there, and then continued on with the clearing procedure. Now, the last part of this clearing procedure is you're going to let the action go forward, in this case, a slide, and you're going to point in the safe direction, which when we're on the range, it's in a berm, and you're going to pull the trigger. Why would we do that?
I guess to demonstrate that it is fully unloaded.
It's good. I like it. So it's to demonstrate that it is completely unloaded. It is also completes the cycle, gives you peace of mind that you did this clearing procedure correctly, okay? And it's in a safe direction. So if you did it incorrectly, you're not likely to have a catastrophic incident. Does that make sense? And lastly, on some firearms are single action, and single action firearms is when the hammer is to the rear, and it's under spring tension, or it could be a striker too. For example, your Canex, the striker's under spring tension, and if you store it that way, the spring could potentially lose its power, let's say, and then now you have to take it to a gunsmith or something to get it fixed or something of that nature. It's always good to have your single action firearms dry fired and in storage if you're going to store them for a long time. So there's a couple different reasons to do that. Now, safe direction on the range is easy. It's in the berm. Where do you think a safe direction would be in your home?
Probably just straight in the ground, I would say.
Okay. Do you live on a second floor? Is your
Yes,
bedroom in the second floor?
But all of my, everything's stored in the basement. So there wouldn't be anything.
I'm sorry?
Everything's stored in the basement, so there wouldn't be anything.
Okay. So you're in the basement. But would you ever have your firearm in your bedroom, let's say on the second floor or third floor?
Yeah, I guess. Yeah.
Okay. So where would it be a safe direction? Always.
I guess there wouldn't be a safe direction.
You really have to think about it.
Yeah.
Now, I've thought about this, and I think, let's say if you're if you're in a bedroom, for example, I think a safe direction is into the mattress.
Okay.
Because if you did have an accident, let's say, that thickness of the mattress would slow down a bullet from going all the way through, let's say, the floor or something like that. because I've thought about this a lot. Like, where would a safe direction be? And if it's in your home, at least in your bedroom, into the mattress or into a couch or something that's going to stop or at least slow down the projectile, okay? If you were to have an accident. So now we're going to talk about avoidance of confrontation. We're going to take a small break. Let's take a small break. You go use the bathroom, get some coffee or whatever you got to do, and then we'll go from there. Yep. You want to go inside?
Sure. Yeah.
Yeah, it's getting a little hot, huh?
Warm.
Yeah. Okay. Cool. Let's go inside. Hey guys, we're gonna move this thing inside. Can you hear me? Can anybody hear me? I don't know. What's going on here? All right, we're going to take this aside. We'll be right back with you here shortly. We're going to cover how to avoid and manage an attack or confrontation when we get back. I'm live again. No, I'm live. We're just taking a break. And we're gonna bring it inside. It's really sunny out there, and yeah, it's getting hot. So, I don't know if you guys can hear me. I had some technical difficulties earlier, and I think we've resolved those. Let's see. Oh, yeah, thanks. All right, we're going to continue. Are you good?
Yeah.
All right. We're going to continue. What's that, baby? Oh, you can hear me? Okay, good. My wife's over here. She's checking this stuff out. But hey, we're gonna continue with the class here. We're gonna talk about avoiding and managing a confrontation. And I have a customer here. We're gonna go to the range after this and actually do some live fire stuff as it pertains to Colorado Law 18-12-202. So let's go ahead and continue. So we're going to talk about avoiding and managing an attack or confrontation, okay? So at the end of the day, avoiding the confrontation is paramount, okay? We have to make sure that we can avoid that situation altogether, because if there's no situation to be had, then obviously there's nothing that could be brought against us in a court of law, for example, okay? So avoiding that confrontation altogether, okay? There's some ways we can do that. We can either take a different route. Let's say we're in Denver or something, and we see an up to no good, let's call them, a block or block and a half down the road, and they're in between us and our destination. Well, what's stopping us from taking a different route, right? Just going one block east or west, north, south, whatever, and then going around that individual. Another one is to have somebody present, right? So if you have somebody present, if somebody's with you, an attacker is not likely going to attack you, because I mean there's somebody there. There's a witness, for example, and that's also support and help. Okay. Women know this full well when they go out as a group, when you go out to the bar or whatever, you'll see like a group of women. They know full well that if you travel together, you're likely going to be safer than if you travel alone. Okay. Use words of respect and kindness. So even if they're not being respectful unkind to you, um, just being respectful and kind to them, it does go a long way, because ultimately people just want to be, kind of respected, So regardless of, how they look or how they perceive themselves or whatever is going on. Maintaining distance. Okay, so this is why I purport to, and you need to have a firearm, even if you're your best MMA, like martial arts, karate genius guru, right? If one person gets one good hit on you, now you're kind of screwed. Okay, so a firearm is something that can help you maintain that distance, and then know and understand your surroundings. So wherever you go to and through, you should have like an understanding of the surroundings, the surrounding area. I'd like to use the example. You shouldn't be southeast Colorado Springs anytime past 10 o'clock at night, because typically speaking, between 10 and let's say 3 o'clock in the morning, 10 p.m. to 10 o'clock in the morning, or excuse me, 3 o'clock in the morning, that's typically when the shootings happen in southeast Colorado Springs. Okay. So just knowing what's going on there. Okay, so before confrontation, be situation aware. Okay, avoid that confrontation, and keep your distance, kind of thing. Okay, we can watch social behaviors. Okay, community knowledge. This is a big one. So when I did a security guard thing up in Denver, there was a lady that came into the store, and she looked like she didn't belong. But instead of me confronting her, I went to the receptionist and said, "Hey, you guys know this person?" They're like, "Yeah, she comes here all the time." So that community knowledge is very important. So I'm sure you know people in your community that are supposed to be there. And if you were to see somebody that weren't supposed to be there, then you're like, "Wait a minute, what's going on here?" Right? Yeah. Okay. Cool. Um, during the confrontation, so this is a big one, right? Because if there's a confrontation that you can't avoid, first of all, you can potentially stop that confrontation just by being polite, or giving the guy or gal having some patience with that person, because sometimes people just need to vent, and you might be the person they're venting to, right? It's like, okay, all right, cool, especially if let's say you're in the business of service. Let's say somebody came in here at the Starbucks and they started yelling at somebody. Let's say they started yelling at somebody, one of the baristas there. Okay, well, giving them some time to vent gives them a lot of time to kind of get that out of their system, and then maybe they come to their senses, right? So some patience goes a long way. Also, politeness, like I said earlier, and being stern. But you have to be prepared to use physical force and or deadly physical force to defend yourself and or third parties if you choose to do so. Um, but if you do defend yourself or others, um, be prepared to call 911 immediately, right? I personally believe you should be the one calling 911, not having someone else call 911, right? And we'll listen to these lawyers here in a minute. Um, there's some things that you can't assert self-defense if uh, if other things are present. For example, you can't provoke someone and then use deadly physical force, for example, and then call it self-defense. You can't provoke somebody to do that, right? Uh, Immediacy, obviously, it needs to be immediate. There needs to be some imminency there, right? Which brings me to a question: do you think a warning shot should be used? Why or why not?
Um, well, I think it's irresponsible.
Okay.
Probably. And a lot of times a warning shot is used whenever, it's not imminent, I guess.
Okay. Yep. I agree with you. Okay. Now I know there's two arguments to the same problem. If I could hear a defense lawyer, let's say, who's defending somebody who did uh, issue a warning shot, I could hear the defense lawyer saying that my client didn't want to shoot the guy. He wanted to stop the threat, for example. And then I could hear the prosecution saying, well, it wasn't imminent. If it was imminent, he would have shot the guy, not done a warning shot. The other thing is warning shots, I mean, they could be wild, right? They could ricochet and hit someone else, an innocent bystander. So I definitely wouldn't suggest issuing a warning shot. If you're going to pull your firearm for self-defense, you need to be prepared to take the consequences of shooting that individual that's imminent, right? All right. And then proportionality, right? So my wife's sitting right over there. She's a petite lady. If she was to attack me and I shot her, I'd have a lot to explain. If it was flip, I attacked her and she shot me, she'd have less to explain, if that makes sense, right? Because she's very petite, very small. And then in this situation, the prosecuting attorney would probably say, well, Mr. Williams is a trained barrel-chested freedom fighter, Green Beret, weapons sergeant, retired, and he's also a firearms instructor, so he knows laws and all these other things, right? And then they would say, well, Miss Williams is a petite, and they'd bring race in there, and like a petite Hispanic lady, she was just minding her own business, whatever it was, right? So proportionality, where this comes into play, in the big picture though, is like I said earlier. Let's say you and I we're about the same height, and let's say you and I were to go at it, and I don't know any kind of medical things you have, but you know your medical things, right? Maybe you're afraid that I do something that's going to be potentially deadly to you, even if it's not with a firearm, and then you turn around and shoot me. Now you can say, well, I was in fear of my life because of this medical condition or something of that nature, right? So proportionality becomes apparent. So we're going to listen to these. We're going to listen to these lawyers, which is armed attorneys. I highly suggest you see those as well. So Washington Gun Law, all armed attorneys. I highly suggest them. They're great content creators. They're going to talk about safe alternatives and reasonableness.
Taking advantage of reasonable, safe alternatives. Now, where did I see this come up? Mostly in the riots in the summer of 2020, when we had people occupying streets, vehicles, lots of chaos, and we saw quite a few shootings that resulted in death over the summer. And this is just a good way to illustrate the point of taking reasonable, safe alternatives. Because juries want to, even in states that have a stand your ground law, we're in Texas. We have a very powerful stand your ground law that says, if you're in a place you're legally allowed to be, you're not committing a crime, you didn't provoke the person, that you're allowed to stand your ground. And a jury will actually be instructed that they are not to consider your failure to retreat for any reason. But I will tell you, as a practical matter, they consider it all day long, even when a judge orders them not to. And so that when we're talking about stand your ground and how juries consider these things, that's where reasonable, safe alternatives come into play, because a jury, it will creep into their minds. Why didn't the person just leave? Why didn't they just turn a different direction down the roadway instead of driving towards a crowd of people, using our example? They're going to think about it. Do you have anything to add to reasonable, safe alternatives?
Yeah, absolutely. And, Rich and I are both former prosecutors as well. There are a lot of trials under our belts. I don't think I ever had a jury that behaved and that did what they were instructed. You just can't stop human beings from thinking about things, especially once you put it in their minds, tell them they're not allowed to think about it. Yeah. Gosh, you can't even stop them from doing their own research about the facts of the case. They go home and Google it immediately, despite the fact that the judges told them not to. So juries.
Okay, so that's pretty self-explanatory, the way armed attorneys described it. Okay, so we're talking about safe alternatives in a self-defense situation here. We're also going to listen to them for reasonableness. Okay, which again is a subjective thing. Now they're going to talk about reasonableness as in things that you can measure
such as the distance, how many rounds was fired, the caliber of the firearm, et cetera, stuff like that. But then there's some subjective things like that are reasonable. Like, would you say, in your own opinion, would you say discharging 7 rounds is appropriate?
In most situations, probably not.
Okay.
It seems like a little bit overkill in a lot of situations.
Okay. What about 1 round?
1 round would probably not be sufficient, I would say. I mean, the general rule I've always heard is double tap.
Yeah. Yeah. Okay. So let me almost throw this at you. Whenever we do a self-defense situation, what's the ultimate goal?
Protection.
Protection. Okay. But how are we going to protect ourselves? What's the
I guess incapacitating the offender in a way.
Well, I wouldn't say that, because if you were to say that in a court of law, you're going to be like, they're going to paint you as a bad guy because, okay, you put it in your mind that you want to stop the threat. You want to stop the threat from being a threat. You don't necessarily want them to die. You don't want them to be hurt, but you want them to stop being a threat, right? So, with that context, how do you know how many rounds is going to be appropriate?
I mean, it really depends on the situation.
It does. And that's the whole point, right? So this is subjective criteria. It depends on the situation. So there's been documented cases in combat where people where the enemy was hopped up on like peyote or whatever, and they were shot 15, 20, 30 times, and they continued to go, right? They continued to go, right? So it's very subjective for the amount of rounds being used, right? And that example that I just gave you about, is 7 rounds too much? Is 10 rounds too much? Is 1 round? Is 2 rounds? So on and so forth. You have to think that a jury of your peers, each one of them might have a different outtake on that. So that's very subjective, okay? Ultimately, the answer is as many rounds as it takes to stop the threat from being a threat. If it's 1, if it's 10, if it's 20. As many times as it takes for that threat to stop being an imminent threat on me or a third person. And you just don't know, right? And you don't want to necessarily hurt the individual or kill the individual. You just want them to stop being a threat. Okay. So we'll listen to these lawyers about reasonableness. So this is, I like to use visual graphics for my classes, and we're going to be listening to armed attorneys here for their reasonableness clauses. Okay, so I'm going to put the microphone by the computer so you guys can listen to.
Better have been really acting in legitimate self-defense, and you better have been reasonable. And that's really the last element I think we need to talk about here, is that almost every state in the country is going to evaluate on whether or not you were objectively reasonable based on the reasonable person standard. So we're looking at, would a hypothetical, objectively reasonable person in your shoes have done the same thing that you did? Now, a jury isn't supposed to say, would I have done this thing if I were in his shoes? But practically, I think that's just how the human brain evaluates these things. So you've got to take someone who you have never met, who may or may not have your same beliefs, your same background, and convince them that they would have done the same thing you did. And, you know, Richard, I think we've learned from trying these cases that if you think other gun people are going to help you in this regard, you might be wrong. Sometimes the strictest jurors and the ones who are most likely to convict in a self-defense case are people who are already self-defense minded, because they look at the incident and they say, well, I've thought about how this would play out. If it were me over and over again, that's not what I would have done. And so it can be tough to get a jury who says, sure, they acted as a reasonable person would have acted.
Yeah, and the reasonable person standard applies to all of those elements that we discussed earlier. It's kind of this overarching catch-all. And when I think about it, I kind of break it into two groups is the way I like to think about it, is your objective reasonableness. That's things that can be measured, the number of shots, the amount of time, distances, weights. The objective factors, juries get to consider that. And in most states and in many states, they get to consider subjective reasonableness as well. What is in the mind of the defender at the time they were forced to defend themselves? Did they have a previous relationship?
Okay, again, that was Armed Attorneys. I highly suggest that you go and check them out. Good content, great stuff. That's where I get some of my things from. But so, as we talked about earlier, there's some things that are objectively measured, and there's some things that are subjective. And I know whatever her name is, she says, who was objectively reasonable. She puts objectively reasonable, and like it's a thing. Lawyers like to do that, but reasonable in itself, the term reasonable is definitely subjective. Okay.
Better have been really.
Okay, so we talked about before the confrontation, you want to avoid the situation. If you can't avoid the situation, then you want to deter the situation. If you can't deter the situation or the interaction, and you have to use physical force or deadly physical force, then what is after that incident? And this is probably the most important aspect of this, because once you use physical force or deadly physical force, you are now subject to investigation as a criminal. Right? Until the investigation proves otherwise, you are now suspect of being a criminal. Okay? You could be charged with assault with a deadly weapon, murder, whatever other charges there are. Okay? Manslaughter, so on and so forth. So, what happens post confrontation? The first thing you need to do is call 911. And I think that you should call 911. I don't think you should allow someone else to call 911 for you. So in California, my brother-in-law, he's also a firearms instructor in California. He had an individual come to the range, get some training. That individual then went to his apartment and I guess forgot his training because he had an accidental discharge, and it was in an apartment. It went through the wall, and luckily it didn't hit anybody, but it went through the wall into another apartment. He called my brother-in-law. My brother-in-law was like, "What are you doing? Call 911." He hung up, called 911. The cops said to him, and I mean, this is third-party information here, but the cops said to him, he's lucky that he called 911 first, because if somebody else had called 911, he'd be going to jail. Okay, so I think that you should probably call 911 immediately as soon as you can, and there's a couple reasons for that. One, you want to tell the dispatch, hey, there's an emergency. Notice my language here; it's very vague. There's an emergency. We need police and EMS. I didn't tell them what happened. I didn't say any specifics. I didn't do anything like that. They're going to ask your description. They're going to ask where you are. They're going to ask you what happened. And you can say somebody's injured badly or some kind of vague situation like that. You can also say, I had to defend myself, and that's it. They don't know what happened. Does that make sense? Because the minute you dial 911, the second that it starts ringing, it's recording. Okay, and anything you say can and will be used against you in a court of law. Notice it's not can and will be used for you. Okay, so you need to assert your. So you call 911. You can give them some vague information just so they can show up on scene. Okay, now when they show up on scene, what are you going to do with your firearm if you used a firearm? Yeah. Are you going to keep it in your hand?
No, definitely not.
Exactly. You don't want to reholster. Yes, I love it. So What I typically tell people is that you want to put the firearm back where you got it from. If it was from your vehicle, put it exactly back where you got it from. If it was from your holster in your waist, put it exactly where you got it from. And do not unload it and make it safe. Does that make sense? Because that could be misconstrued as tampering with evidence. Because that gun now becomes evidence. Okay, whatever is used is going to become evidence, and you don't want anybody saying that you tampered with that evidence. Okay. So I tell my customers, put it back where you got it from, in the exact configuration that it was. Okay. You definitely don't want to look like the bad guy to the police that are showing up. Okay, because they likely know there's been a shooting. They don't know if you're a good guy or a bad guy with a gun. They're still trying to figure that out. And we're going to listen to some lawyers on this. Okay, and we're going to listen to 3 separate channels. And it's going to be 1, 2, 3, 1, 2, 3. We're going to listen to 4 different lawyers on this subject specifically, and they all say the same thing in general, right? There's some similarities. There's some differences. Some of them say you should call 911. Some of them say that maybe somebody else should call 911, but they all say the same thing: is that when in doubt, shut your mouth. Invoke your right to silence and counsel. Remember, the 5th Amendment is the right to remain silent. The 6th Amendment is the right to counsel. So invoke both of those rights together, and just keep your mouth shut, and then talk to a lawyer. Okay? So
would that mean like on the scene when they're asking for a statement?
On the scene.
Just say, I would like to wait till my lawyer's here to speak.
Yes. So invoke that right immediately, right? They're going to do the investigation. And this is my general understanding. If you only invoke your right to remain silent and they press you and you start speaking, it's possible that whatever you say still is going to be used against you in the court of law. Now, if you invoke your right to remain silent and to counsel, if they press you and you start saying something, because you've invoked your right to counsel, that whatever you say after that, because maybe you're frightened, okay? Who knows what state of mind you're in. If you invoke your right to counsel and they press you, then everything after that can be inadmissible in a court of law. Okay? Does that make sense? So that gives your lawyer some ammunition, pun intended, to defend you in a court of law. Okay? Because, again, you don't know when the situation will present itself when you potentially have to defend yourself with physical force or deadly physical force. If, let's say you're in Denver and you're in Denver County, I imagine the prosecutor there is not going to be very gun friendly and not very self-defense minded. And they're going to probably charge you with some kind of crime in that county. Now, if you're in El Paso County, it's not likely. I think the prosecutor's pretty good here, at least for the time being, okay? So, again, you just don't know. So we're going to listen to these 3 lawyers. For my audience online here, we're going to go ahead and shut this live feed down. We're going to listen to Armed Attorneys, Washington Gun Law, and we're going to listen to AOR. By the way, I'm an AOR affiliate. The link is below. Go check them out. I have them as my coverage, and I think that probably you should get them as your coverage as well. If you do use my link, you'll get $25 off of your sign-up fee, and you'll be covered. So it's a win-win-win. Now, if you do get coverage through AOR, in order for that coverage to stick, there's 3 things that have to happen. 1, you have to be an AOR member. It's pretty self-explanatory. 2, you have to be able to reasonably assert self-defense, and it has to be in good faith. Meaning you can't go and murder somebody and then get coverage, okay? That's not the way it works. And then 3, you have to be charged with a crime or reasonably believe that you're going to be charged with a crime. And if you assert yourself, if you have to use your firearm in self-defense, you're likely going to be charged with some kind of a crime at some point. So those are the 3 criteria.
Go check them out and decide for yourself. But if you use my link, I get a small commission, and you'll get $25 off of your sign up. So we'll see you later. Tack out.